Case number SP 146436761, SP 146409991, SP 1463900, counts 1, 2, and 3. State your name for the record.
Grayson
Bay. I'm sorry.
Thank you.
State your name for the record.
Grayson Bay.
All right. This is today is the date and time set for a jury trial. Ms. Schneider, can you put your appearance on the record, please?
Good morning, Your Honor. Alexis Schneider for the people, P80322. For the record, the issuing officer, Officer Ambrose, was present, although I released him.
Mr. Grayson Bay, we didn't conclude some of the. First of all, I want to.
Before we even step into the courtroom, let's set the stage for what you're about to witness. Because this isn't just another sentencing hearing. This is the conclusion of the Grayson Bay versus Judge Perkins saga, a case that escalated from a jury trial setup into a full-blown courtroom confrontation, where legal arguments, sovereign citizen ideology, and judicial authority all collide in real time. Yesterday, we saw Grayson Bay found guilty on multiple charges, and the expectation was simple. A jury trial would continue to resolve the remaining counts. But that never happened. The prosecution made a surprising move, dropping the final charges entirely. That decision shifts everything. Instead of a trial, we now enter sentencing territory, and this is where tensions usually peak. What makes this case especially compelling is not just the legal outcome, but the clash of worldviews inside the courtroom. On one side, a judge bound by legal procedure and precedent. On the other, a defendant challenging the very foundation of jurisdiction, law, and legitimacy itself. And if you've watched these types of cases before, you already know things rarely go smoothly when sovereign citizen arguments enter the courtroom. Misinterpretations of case law, jurisdictional denial, and procedural confusion often collide with hard legal.
And did not obtain the license to assemble. That was a case where he has another reverend organized a sit-in and at a restaurant, and they were ticketed. And the unfortunate part about it is, and that's just how our society is, and it was, and still is for the most part, is that this case had to go all the way to the United States Supreme Court for him to get justice on this case. But again, you're citing all the cases in there, all the cases that you have cited are saying exactly the opposite of what you purport. Have you looked at any of them?
Yes, Your Honor.
And you read them? When did you do that last night?
I've been studying more science. My religion is more science. As you can see, if it looks like a judge asked.
We witness something that almost always triggers tension in these cases. A judge actively correcting legal misinterpretations on the record. Judge Perkins doesn't just disagree. He breaks down the cited Alabama case and clarifies what actually happened, emphasizing that it involved organized protest activity and Supreme Court escalation, not the simplified version being referenced by the defendant. This is important because it highlights a recurring pattern in sovereign citizen arguments: selective reading of case law. The judge's frustration is not just about accuracy, that it's about misuse of legal precedent in a courtroom where precision matters. And here's the bigger issue. When case law is misrepresented, it doesn't just weaken an argument, it undermines credibility entirely. The judge even points out how incorrect citations can have professional consequences for attorneys, which raises the stakes even higher. Clips. Now, this is where the tone shifts dramatically. The duck test analogy enters the conversation. If it walks like a duck and talks like a duck, it's probably a sovereign citizen. While humorous on the surface, this moment reflects something deeper. Courtroom frustration turning into sarcasm. This type of commentary from a judge is rare but revealing. It shows how repetitive and predictable certain legal arguments have become in similar cases. The humor isn't just entertainment.
It's nothing about, you can see it. I just wanted you to acknowledge, I do acknowledge the fact, and I appreciate the fact that you have support here. The court always recognizes that. That's why I asked you to stand up. But you want to remain mute now, but you didn't remain mute when you filed these pleadings. This is how you speak to the court, exactly the way you did. Now, maybe the form is not exactly the way the court kind of or the rules have to fly, but I understand you're in pro per and you might not know all of those rules. But when you start filing these documentations, you're speaking to the court and you're representing that this is the current state of the law as this is the current state of the law, and this stuff applies to your case, and I should be reading this stuff and be able to interpret what you're saying about your case through these cases. And when I read these cases, it says exactly the ones that I've read, and I've seen these cases filed before, it says exactly the opposite of what you're trying to say. Because what I understand you're trying to say is that you're trying to say that you don't need a valid driver's license to drive on the roads, you don't need proper registration on your vehicle, and you don't need proper insurance. And you're even going as far as saying that the police officers, and correct me if I'm wrong, that the police officers do not even have the authority to pull you over.
Turning point, the defendant introduces a personal belief system centered around science as religion, mixed with analogies and philosophical reasoning. From a legal standpoint, this is where things begin to drift away from procedural relevance. Courts require legal arguments, not ideological frameworks. And while personal belief is protected, it doesn't replace statutory law.
And I gave you pretty much documents to read, and I'm standing on those documents, and I'm gonna remain mute. Thank you.
All right, so I've already found you guilty of the count of refusing to exhibit a driver's license, SP 1464091. I'm going to fine you on that case $240. I've already found you responsible on SP 1463901, expired plate. I'm going to fine you $145 on that. And I've already found you responsible on SP 1463903, insurance no proof, and I say guilty on SP 1464091, and that's a 240 for the insurance no proof. I'm going to fine you $195 on that. All right. As far as the other counts, I had in the note. Well, you told me off the record that you're going to dismiss SP 146436761 and SP 146390002. Is that correct?
That's correct, Your Honor.
So 145, 195, and $240, sir. When can you pay?
I will probably need after the holidays, maybe 3 months. I might get something up for you.
Are you working?
I do carpentry.
Yeah, you do carpentry. Are you working?
Yes. Yeah, I have jobs lined up.
Okay, so why do we need so much time?
A subtle but emotionally charged moment. The defendant repeatedly states he remains mute, invoking silence as a form of legal stance, while simultaneously referencing his mother's presence in court. This creates an interesting contradiction. Silence as protest, yet continued engagement with the proceedings. The judge acknowledges the family presence respectfully, but quickly redirects attention back to legal procedure. This balance between empathy and authority is one of the most important aspects of judicial.
Play on word. I mean, it's the truth, though. I mean, I got to speak the truth to you, right?
You're
respect
not
the truth?
working now. If you.
Okay, I'm not
asking
working
you-
today. I'm not working.
No. You're not, I'm asking you, why is it taking you 3
We-
months to get up? I don't typically give out 3 months to pay fines, especially when somebody's working, and especially in a career that's a skilled trade, that's a very lucrative career. So I'm trying to give you the time you need, but I need to make a good basis for that.
3
Because
months.
you're not giving me a good basis for giving you 3 months, and you're telling me you're a carpenter and you're telling me you're working. Now, if you're telling me you're a carpenter and I'm not working currently, then that's something that I can go with. But you're telling me I'm just not working today.
Right.
I'm gonna go to work tomorrow.
Well, we
I'm
optimistic,
going to work
yeah.
tomorrow, and I'm going to work the next day.
Yeah.
So I'm not giving you 3 months.
I'm very
for that.
optimistic. That's why I say, well, as this present, not, but yeah, tomorrow. I'm very optimistic about work. So yeah, yeah.
So you're not working.
Today I'm not working. Tomorrow I'm going. I have grass work tomorrow to do. There are schedules to do, and I do have a future as a job to have things to be done. But as you saying, as I'm working, I'm telling you the truth. Not as now, no. If that clears, if that makes you feel comfortable,
No,
no, I'm not working.
I'm trying to ascertain.
No, I'm
what's
not
going
working.
on, sir.
I'm not working at this present moment. I'm not working.
And when you say you're working, you have some aspirations of working,
Yes.
like everybody does. We're
Yes.
looking for, well, not everybody, because not everybody is trying to work.
Right, exactly.
So
Yes.
you're not working now,
Right.
correct?
Thank you, Your Honor.
Let me ask you this, ma'am. Is this the kind of, I don't know, I want to make sure that you don't need.
Escalates, while the judge directly questions whether the defendant understands his rights, specifically the right to remain silent versus the ability to actually exercise it. This is a crucial legal distinction. Many defendants invoke mute or silence as symbolic resistance, but in court, silence has to be strategic, not rhetorical. The judge is essentially testing whether the defendant understands the consequences of selective participation in proceedings. And this is where the courtroom power dynamic becomes very clear. The court controls procedure, timing, and legal interpretation, regardless of how a defendant chooses to frame their participation.
I don't feel you're speaking the truth to me.
I'm not working today at this present moment. I'm not working.
And you're not working, you don't have anything set for tomorrow,
No, I don't.
right?
Nope, I don't. I don't.
You don't,
I'm
do you
not
have
even
anything
working.
set for next
Nah.
week?
No, I'm just anticipating things. You're right. I don't.
Do you understand what I'm saying?
Exactly.
I'm just gonna get you out of here. I'm gonna give you, till March the 5th. You can either Zoom in or come in.